Hi there, and welcome to this CM Murray 10-minute talk on the new Employment Rights Bill. My name is Beth Hale. I'm a partner at CM Murray and our GC, and I'm delighted to be joined today by Mitchell Blythe, who is our trainee. Um, so this has been, Mitchell, a really exciting week for employment lawyers,
Yeah,
or perhaps a really exciting week for geeky employment lawyers like me, but uh, certainly a busy week for employment lawyers. The bill was published last week, and it is taking us, it's 158 pages of reading to do. It's taking us all a lot of time to sort of get our heads around exactly what's in it, and really importantly also what's not in it. Um, we aren't going to cover, and I don't think we could cover in a 10-minute talk, the whole bill. So today we are going to focus on two key areas, and then we will cover some of the other areas in future discussions. So I'll just hand over to you, Mitchell, to sort of tee up what we're going to talk about.
yeah. So the first area I think we should talk about is the day one right to request flexible working. It's important when we talk about this as well, I think, to make the distinction between the right to request flexible working from day one and the right to flexible working. So this is focusing specifically on the right to request flexible working. And this is something which has already undergone reform in 2024 and has actually been in the works since I think December 2022. And I understand the Employment Rights Bill is set to impose some further obligations regarding this. Is that correct, Beth?
Yeah, absolutely. So you're absolutely right to make that distinction between the right to request flexible working and the right to work flexibly. And I think that in the run up to the election and in the run up to the introduction of the bill, I think what the press was certainly reporting was that there was going to be everyone's going to be able to work 4-day weeks. Everybody's going to be this sort of dramatic change. Everybody's going to have a right to work flexibly. I think employment lawyers always knew that actually having a right to work flexibly, it kind of doesn't work, because there are lots of jobs in which it is just not possible to have those kinds of flexible, to have certain types of flexible working arrangements. Employers will always need some flexibility um, around what they can and can't permit for certain employers, what they can and can't agree to. So I think it is no surprise to discover that in the bill they have not introduced a right to work flexibly, but what they have introduced is a sort of strengthening of the right to request. So already from April of this year, the right to request flexible working, so the right really to request changes to your working hours, changes to your working arrangements, whether that's changes to hours, I say, or working from home, working flexibly, working remotely. The right to make that request was already a day one right since April this year. And what the additional bit that they have now added is an extra burden on the employer, to an extra onus on the employer to behave reasonably in determining whether they allow a flexible working request. So there are already 8 statutory reasons for which an employer can turn down a flexible working request. And what this bill introduces is an additional obligation to consider those reasonably and to apply them reasonably. So it's a further reasonable test. What it doesn't do is increase um, the sanction for failure to comply with the right to request. It's still 8 weeks' pay, is the cap on a claim for failure to comply with this right properly. But it does provide that sort of extra hurdle for employers to jump, and I think should be making employers sort of think quite carefully about whether it is reasonable to refuse a flexible working request, which I think in any event it's worth saying. I think in any event has become harder post um, post lockdown, post COVID, when flexible working has become the norm for so many people. I think it is harder to sort of turn down requests since in 2024 anyway.
Now, one of the tricky points to consider for employers um, when this was first being discussed was whether or not it'd be discriminatory to ask employees during the recruitment process whether they intend to immediately put in their application for flexible working, especially for employers who have companies or have employment where the role is not suitable for such a work pattern. Are there any more sort of further considerations for employers to consider in light of these obligations that have been brought in with this bill, will be brought in with this bill?
No, so I think that still remains the case. I think it just, I think it still, employers still are able to turn down flexible working requests, and they still are able to, in certain circumstances and where it is reasonable and appropriate to do so, to say actually in job adverts, this is a full-time role, this is not a flexible working role. Whatever they ask in recruitment wouldn't remove the right from someone. An employer could still turn up on day one and make that request, and the employer would have to deal with it reasonably. So I think it does mean that employers will have to at all times be thinking about, is there a way that this can be done, this job can be done flexibly, and is it reasonable to say that it can't be. So I think it does just give that extra pause for thought about what employers need to do, and the sort of knee jerk of going, well, it's a full-time job and they have to be in the office every day. I think it really, you just have to, employers should be thinking, can it be done flexibly? Are there, and be open to suggestions from employees about what flexibility looks like for them. There's no one way to be flexible. And I think that employers will have to be more flexible themselves in considering these kinds of requests.
Yeah, I agree. And I suppose it's also a good opportunity for employers to get their policies in order.
Absolutely, yeah.
We'll move on to the second part of the Employment Rights Bill that we'd like to discuss today, which is the changes to the right not to be unfairly dismissed, or more specifically, the changes to the qualifying period for the right not to be unfairly dismissed, which is currently a 2-year qualifying period before an employee, as a starting point, can bring a claim against their employer for dismissing them without a fair reason or for not following the fair process in the dismissal. Can you talk us through the big change that is coming with this Employment Rights Bill?
Yeah, so what this was billed as in advance was that unfair dismissal was going to be a day one right, so that there was going to be no qualifying period. Now, an easy way of doing that would have been to simply amend the qualifying period in the Act, which is 2 years, but it has bounced around between 1 year and 2 years between different governments, different regimes. So that it would have been very easy by statutory instrument to change that qualifying period. What they have in fact done in this bill, or what they're proposing to do in this bill, is remove the qualifying period altogether. So to remove the section which refers to the qualifying period, which doesn't just change the qualifying period for this government, for this parliament, for these purposes. It also means that no one can, that it won't be as easy to reintroduce a qualifying period in the future, because it would have to be done by legislation, and so that will be complicated to do. So it's worth saying that they are obviously trying to do this as a sort of permanent change. The other thing, a few other things to note, are that it is going to be a day one right. From the moment someone starts employment, not before, other than in certain circumstances, but broadly from the moment someone starts employment, so they walk in on their first day, they have the right not to be unfairly dismissed. But the details around what that means are still very much to be discussed and to be consulted upon. There is going to be a thing called an initial period of employment, which seems to be broadly a probation period. The length of that initial period of employment, that statutory sort of probation period, is yet to be determined, although it's likely, I think it's going to be 9 months. That's what the government is suggesting. But the details of what that means and the impact of that sort of initial period are yet to be ironed out. And I think that there's still lots left to consultation.
So there's been a lot of speculation about the length of that period as well. I know they've been given a little bit of indication that it might be 9 months. Do we know how this will be decided, this period?
So I think they're going to consult on the length of the period and and what that means. So the current indications are that it is likely to be 9 months, as I say. I mean, right up to the day before the bill was published, there were rumours circulating about that it was going to be 6 months. There were rumours circulating it was going to be 12 months. They obviously landed somewhere in between. So I think it's, that has obviously been a real difficult issue for them to resolve, for the government to resolve, in discussions with unions, in discussions with employer groups. So I think that they will consult on that, and people will have views. But what they're proposing is that the process to be followed for a dismissal, so the sort of hurdles for an employer to jump in that initial period of employment, will be less than than after that period. So there will be a sort of lighter touch process expected of employers in that 9 month period or whatever it ends up being. There is also they are also consulting on whether the compensation for an unfair dismissal in that period might be lower than the cap on compensation in that initial period might be lower than the cap on compensation, which is currently £115,000, 115,115 pounds, or 12 months salary, whichever is the lower. But I think that what they're proposing is that it would be a lower sum during that initial period of employment. But there is so much detail to be ironed out about what that looks like, what the process looks like, and whether in fact they're going to sort of impose a statutory disciplinary process, a statutory dismissal process during that period, which will send a shiver down the spine of many employment lawyers who remember the statutory disciplinary and grievance procedures that were abolished quite quickly after they were introduced.
So we know it's still early days for this employment rights bill. But in light of these proposed changes, are there any key steps that employers or employees should be considering to take now, or is it too soon to act?
Well, as I say, there's a lot still to be ironed out. There's loads still to think about and to understand what the detail. And I think I've heard more the phrase "the devil will be in the detail" more in 2024 than I ever before in the rest of my career. That remains the case. I think the devil still remains in the detail. There's going to, there will be a lot still to come out. I do think that one thing that employers can be thinking about, well, two things actually. One is you've already identified, looking at their flexible working policies, thinking about how they manage flexible working applications. And the second one is thinking about their probation period processes. They are often very casual probation periods. I mean, employers, whether they exercise them at all, whether they use them at all, they often have quite casual processes around that and what that looks like in practice. And it will vary depending on from employer to employer whether they confirm the end of a probation period in writing, whether they actively monitor performance during that period. And I think it will become much more important for employers to be doing that and to be thinking about what that looks like and how they can effectively monitor performance during a probation period, so that they can, if a termination is appropriate and necessary, they can do that early with sufficient evidence. But I think too early to put in place formal processes and procedures to deal with the provisions of the bill when we just don't know exactly what it's going to look like. So thanks so much, Mitchell. It's been really good chatting about it. As you know, I've done quite a lot of talking about it over the last week or so it's good to do some more. We will be putting out a few more of these 10-minute talks just dealing with some of the key points from the bill. If you have any questions or anything you would like us to cover in a future 10-minute talk, do get in touch at info@cmmurray.com. And we look forward to seeing you soon.
Thanks, Beth.